Lori Daybell claimed she was so ill in court. She delayed court for multiple days. She showed up with a wheelchair. The judge had to order her be physically brought to court. She tried to get a new judge because of her illness, and now is trying to get a new trial due to her illness. The state's response was pretty basic. We want to get a hold of her medical records to take a look at that, and then because we're doing that, we want to seal everything. And if you haven't watched my previous video, we do have the response where the judge says Lori claimed she was ill. There wasn't enough evidence that there was a reason she had an illness. She couldn't proceed to trial, and that the state will, in fact, be getting her medical records. But this comes before the judge's decision, and I'm only just now getting a hold of it, and it's looking like it's going to be really interesting. And the reason I say that is, in the bottom right, I'm already seeing Newton's third law, and I don't know why. Let's get into this. The defendant, Lori Daybell, hereby requests this court grant the defendant's motion for new trial. There is a violation to USCA, hard to read for me, Fourth Amendment violation, medical evaluation, lack of impartiality, and advisor of discretion, something a rule, denial of Rule 13.5 hearing, not releasing the jury from admonition on the record. Okay, so I believe the denial of the 13.5 hearing, that is her complaining about, I might be wrong on this, it's been a bit. I believe that's her complaining that she was going to have to go through a aggravation phase for her sentencing, and that made her mad, I believe. The judge did forget to release the jury in front of her, but that was after the verdict. The jury was sent out because Lori was being kind of annoying when it came to the aggravation phase, and they needed to solve that outside of the presence of the jury. So, yeah, that was a mistake. It's not enough, as far as I know, to get her a new trial. She says allowing GSR and DNA evidence without sufficient foundation and denial of right to confront witnesses. She got to confront all the witnesses that were there. They definitely gave foundation to the evidence. She had some witnesses she didn't serve or had no reason to bring them up, but none of this is true. Thus, violations of due process, Brady rule, Frey rule, a bunch of stuff, Bill of Rights, something amendment, another amendment, rules of, I can't read that one. Evidence again, 501, 702, Dobert junk science, Newton's third law, Strickland. I tried to search Newton's third law, Strickland, couldn't find it. If you know what Newton's third law is in this context, please let me know. In the state's response, pages 3 to 6, 9 to 10, Ms. Trina K acknowledges the state is in possession of the defendant's medical, to which her colleague, Mr. Joseph Vigil, illegally obtained through MCSO. God, why can I not read her writing? Estrella Administration and CHS. Mr. Virgil produced on June 3rd, 2025. Mr. Vigil, I guess, filed a response to the courts. Mr. Vigil did not obtain the results for the defendant's urinary tract infection. Is that why she's saying she should, she wanted court delayed? Okay. Because the test was sent to labs outside CHS and MCSO, therefore the record was incomplete and incorrect, misdiagnosing the defendant's actual illness. On June 8, 2025, CHS informed the defendant antibiotics were given for treatment. On June 4th, 2025, MCAO civil attorney Mr. Joseph Vigil presented the defendant's medical records and evaluation to the court and the public. That's not true. They cleared the court for this. Because I was watching the trial. They cleared the court. And Judge Kranick mentioned that she made her medical information public. This must have been what he's referencing. They did not make it available to the public. Lori Daybell did. On page 10, Ms. K states she had a viral infection and urinary tract infection. The judge ordered antibiotics therefore. Mr. Vigil, misdiagnosis and incomplete record jeopardized the safety, well-being, and deprived the violated multiple statutory constitutional rights of the defendant. Mr. Vigil is not a CHS civil attorney. Ms. Kimberly Chamberlain is, because Mr. Vigil and Ms. K admit to obtaining the defendant's medical records of MCSO Estella administration, which MCSO admin gained through the CHS bypassing Ms. Chamberlain, who legally represents the CHS and is obligated to obtain a comment, waiver or court order to privilege patient physician records. Holds Mr. Vigil and Miss K, the court's MCSO, sterilization, and CHS in multiple violations. Now, mind you, none of this worked, and they're getting all the files. Just remember that when she's making all these claims without real evidence, as far as I can tell. This discovery conflicts with the Bill of Rights in a direct manner. Then due process is a superior right. USCA Amendment 6, information sought includes information which she is entitled to a matter of due process. The state and Mr. Vigil failed to produce the court for a camera review. Mr. Vigil on June 4th, 2025 read the defendant's medical records to the court, which the public had access to obtain the results. The courts did not seal until later. I don't know. She's claimed this a few times, and I haven't seen it out there until now, right? Physician-patient privilege cannot be compelled. A patient can only... By the way, she is serving life during all this when she's like, my rights. Waive in writing, bar by consent or by court order. The disclosure of medical records violates the defendant's right to confrontation clause and HIPAA. I get the feeling that this was all done legally and she just doesn't like it. Like most things that happen in this trial, done legally and she doesn't like it. She thought it was, she thought there were illegal things done about getting cell phone records too, right? The court abused its discretion by allowing disclosure of the medical records and forcing the defendant to an evaluation. The Bill of Rights must yield to the federal and state constitutions, mandate due process and Brady violation. The state fails to produce justification of lack of impartiality. The defendant has FTR to support the fact-finding. And that court supported the state objections. So she's saying that the court agreed with the state, therefore they are biased. The state failed to produce justification of lack of impartiality. Defendant has FTR to support it, blah, blah, blah. The defendant was unable to admit exhibit as the state and courts continue to state she would open the door to her prior convictions. As she was, we heard that so much that she would just try to do things that would open the door to her prior convictions. She wanted to do it. It sounds like because her appeal based in Idaho is literally based on them bringing up the Arizona stuff. So it sounds like she wanted to mix the Idaho stuff into the Arizona stuff so she can get an appeal at one. She can probably get an appeal on the other and all that shit. And that didn't work out. And now she's not really happy. She tried to open that door. I'm of the opinion that she wanted to open that door to try to help her appeal. She was denied sidebar. She was denied sidebar a couple of times when it was very evident that she wasn't allowed to do something and was told multiple times, and she was told no because the answer is no. Denied photos for presentation of cross-examination because the defendant's investigator was ill with the same symptoms as the defendant. Not a urinary tract infection, right? Right? Again, it's not, I don't think it's the court's issue that her expert is so ill they have photos they can't bring in, because those could have been given to her at any point. Abuse of discretion, denial of Rule 13.5 hearing. The court denied request stating that the defendant was not entitled to a probable cause hearing. The state asked the court to proceed with 2 aggravating factors. Yeah, so the 13.5 was about the aggravation phase. Remember, if you watch the first trial, she just doesn't like the aggravation phase because the jury would get to hear how terrible she is. So she wants to skip it, and she can't do that without admitting to it all. So that's what she did. The state asked the court to proceed. The legal sufficiency of an alleged aggravating circumstance allows the defendant to request a probable cause determination for alleged agreements, the right to double jeopardy, protection from the yeah, okay. Basically, if I remember right from the court, it was an aggravating charge from the grand jury, so she's not entitled to the new hearing. She didn't understand. And it's not like she didn't understand. She refused to understand, right? The court abuses discretion for late disclosure. Rule 15.7, Tammy LeChick's testimony, because Ms. LeChick refused to testify during trial, the court allowed to present hearsay from Ms. LeChick from colleagues, Detective Pillar. I don't think there was any hearsay. All he said was he watched LeChick collect evidence, watched her do it. That's not hearsay. That's him watching something. That's his witness testimony. But she's mad that that woman couldn't be called. The state presentation of expert testimony should have been excluded. When expert testimony is offered as evidence, the district court acts as a gatekeeper, excluding junk science. This does not meet the standard of reliability. An expert's testimony may properly be excluded if there is too great of an analytical gap between the data and opinion. Through expert testimony, approximate cause will not be established, but mere guess and conjecture. That took me a second. I hate this style of writing. To General Electric Company, sorry, it looks like it's important here. Oh. Let's see here. By allowing GSR and DNA evidence without sufficient foundation and denial of right to confront witnesses, Ms. LeChick, June 3rd, 2025, in the middle of that trial, indicated she would not be testifying. The defendant objected to two forensic scientists testifying about the analysis that completed based on the work and conduct by Ms. LeChick. Again, they had someone who watched her collect the evidence, and then it was sealed and chain of custody was held. So her argument here, I think, just falls flat. Was not present when the evidence was collected by Ms. LeChick. Each expert stated collected by witness Ms. LeChick, but was not present when the evidence was collected. Right, but someone else was, and that's how the custody was. Yeah, we went through this at the trial. She didn't like the answer at the trial either. On page 8 of the state's response to the motion for a new trial, Detective Pillar, case agent, he observed Ms. LeChick collect the GSR, so now she's admitting to it, and the DNA swab testing. Then stated he was trained on how to collect this type of evidence. Detective Pillar is not a forensic technician, nor is his expertise establishing a mere guess and conjecture. His testimony could, on behalf of Ms. LeChick, should have been excluded due to analytical gap between data and opinion, junk science. The court abused its discretion by failing to inform the jury on the record and in front of the parties that they were released from admonition. So now literally the argument here is generally the jury is released to do free people things. They have access to talk about the case, look up the case. They weren't released in front of Lori because they were sent out, and Lori threw a fit about the aggravating factors, and again stipulated, and she had left, and I guess they forgot because she had left and it wasn't done in front of her. This alone supports defendant's motion for a new trial. The legal rules governing the outcome of a case, admonition, which tend to be cautionary statements regarding the jury conduct, such as statements requiring the jury to disregard certain testimony, James v. Kentucky, reverse reprimanded, admonition, a violation of UCSG, whatever. And the state's response, Trina K. avoids addressing the court's abuse of discretion and violation of the admonition to correct with the courts. What is she arguing the harm was here? Like here, so she's trying to explain the admonition, right? Which a cautionary statements regarding the jury's conduct, such as statements requiring the jury to disregard certain testimony. The trial was over. They were forgotten to be released from it. It was so they were under it during the whole trial. Like, this is just nonsense to me. Maybe I'm missing something big legally she's basing it off of, but it's Lori, so I doubt it. Conclusion based on the above for finding the state has failed to actual facts to support their claim. The state lacks justification all the above. The defendant requests for motion for new trial should be granted based on bias, prejudice, abuse of discretion, and most importantly, the violation of admonition, which the state is desperately putting. How is that the most important? I am losing my mind. How is the most important thing? So the jury is brought under admonition, right? They do the whole trial. Lori is found guilty. Lori um gets to the aggravation phase. She stipulates to all of it. So the trial is done, right? Everything's done. There's nothing more for the jury to do. And they forgot to release the jury in front of her, right? How did that affect the results of the trial? That is where I am stumped. How is that the most important? And the fact that she's saying that's the most important makes me feel like she's realized that all of her other stuff is completely worthless because she's kind of admitting it at the end. I don't understand it. I don't see how Newton's third law came into this either, but there it is. There's her complaint, and it failed. It failed. The state's going to get access to all of her medical stuff, and we're not going to get to see it unless Lori decides to complain about urinary tract infections again in a public facing document such as this.